Hello, YouTube. Woo-hoo. I took off from the gym tonight and I'm doing an early broadcast. And I broke my fast with mulberries. And I got ingredients to make a salad. So that's what's up. What else is up? The Supreme Court rules 8-1 that lawmakers in North Carolina can intervene in litigation to defend a state voter ID law. The NAACP is challenging the law, and the new North Carolina Attorney General is defending it. Legislators want to intervene anyway. The Supreme Court says they can. Let's see. In 2018, North Carolina amended its constitution to provide that voters offering to vote in person shall present photographic identification. To implement the mandate, the General Assembly vetoed the bill. The governor vetoed the bill. The General Assembly overrode the veto, and it went into effect. The state conference of the NAACP, what is that? National Association for the Advancement of Colored People. Okay. Then sued the governor and members of the State Board of Elections, a state agency whose members are both appointed and removable by a governor. They allege that it defends the federal constitution. The board was defended by the state's attorney general, who, like the governor, is an independently elected official. The attorney general at the time was a former state senator who voted against an earlier voter ID law and filed a declaration in support of a legal challenge against it. The Speaker of the State House of Representatives and President of the State Senate moved to intervene, arguing that without their participation, important state interests would not be adequately represented in light of the governor's opposition. The board's allegiance to the governor and his tepid defense in parallel state court proceedings and Attorney General's opposition to earlier voter ID efforts. The district court applied a presumption that the legislative leaders' interests would be adequately represented by the governor, board, and the attorney general, and denied their motion to intervene. Unsatisfied with the board's defense following the denial of their motion, the legislative leaders sought to lodge an amicus brief and accompanying materials, but the district court refused to consider them, struck them from the record, and granted a preliminary injunction barring enforcement of it. The Fourth Circuit considered both district court rulings in separate appeals before separate panels. On the preliminary injunction ruling, the panel held that the district court had abused its discretion because the record contained insufficient evidence to show that it violated the federal constitution. On the intervention ruling, a separate panel agreed with the legislative leaders and held that the district court had erred when denying them leave to intervene. Eventually, however, the Fourth Circuit decided to rehear the matter en banc and ruled that the legislative leaders were not entitled to intervene in the district court proceedings. This court agreed to hear the matter to resolve disagreements among the courts of appeals on the proper treatment of motions to intervene in cases like this one. North Carolina's legislative leaders are entitled to intervene in this litigation. I'm really not interested in this. At the heart of this lawsuit lies a challenge to the constitutionality of a North Carolina election law. But the merits of that dispute are not before us, only an antecedent question of civil procedure. Are two leaders of North Carolina state legislature entitled to participate in the case under the terms of Federal Rule of Civil Procedure? Within wide constitutional bounds, states are free to structure themselves as they wish. Often they choose to conduct their affairs through a variety of branches, agencies, and elected and appointed officials. These constituent pieces sometimes work together to achieve shared goals. Other times they reach very different judgments about important policy questions and act accordingly. This diffusion of governmental powers within and across institutions may be an everyday feature of American life, but it can also pose its difficulties when a state's laws or policies are challenged in federal court. Suppose someone seeks to attack a state law. This is just the worst, most boring thing, and I'm not going to read it. I'm sorry. I don't care about voter ID laws. I think the voting system is rigged. Your vote doesn't matter. They decide already beforehand who's going to win, and it's all just a show to make people think that they have a choice in their elected leaders. The leaders are elected by the corporatocracy. And your vote doesn't matter. The only vote that matters is where you put your money. And even that's questionable. I shouldn't have ate today. I feel like shit. I mean, I don't feel like shit. My brain is not working properly. It's like, I can't even eat anymore. What the hell's wrong with me? Supreme Court strikes down a New York gun control law that required people to show proper cause to get a license to carry a concealed handgun outside the home. The vote is 6-3. The Supreme Court strikes down a New York gun control law that required people to show proper cause to get a license to carry a concealed handgun outside the home. They struck down a gun control law that requires, so now they don't have to show proper cause to get a license to carry a concealed handgun outside the home. Okay, here we go. The Supreme Court struck down a New York State law requiring blah, blah, blah. The court said the law violated the Second Amendment. The ruling is a major victory for gun rights advocates who had challenged New York's restrictive law, which makes it a crime to carry a concealed firearm without a license. It also represents the Supreme Court's biggest expansion of gun rights in more than a decade, and casts doubt on laws in 8 other states and the District of Columbia that restrict concealed carry permits in ways similar to New York. The Supreme Court's 6 conservative justices voted to invalidate the law, which has been in existence since 1911. Justice Clarence Thomas wrote the majority opinion in the case, known as the New York State Rifle and Pistol Association Incorporated versus Bruin. The court's 3 liberals voted to uphold the law. Justice Stephen Breyer wrote a dissent to the ruling. In his majority opinion, Thomas wrote that New York's law violated the Constitution's 14th Amendment, which says citizens have a right to equal protection under the law, because it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms, as authorized by the Second Amendment. The ruling comes weeks after mass shooting, blah, blah, blah. So proper cause means that employee has been convicted of any crime involving larceny, embezzlement, or conversion of it. No, that's not. What? Proper cause. I just can't. I can't read. I'm sorry. I don't care about guns. FDA bans juul e-cigarettes. Wow. Good. The Food and Drug Administration rejected Juul's application to sell its e-cigarettes in the United States. They must stop selling and distributing its products in the country immediately. Mike, one of the guys at my gym, smokes these things, so good riddance. His cardio sucks. The FDA said it didn't see clinical information that suggests there's an immediate risk to using Juul products. Then why'd they ban it? Juul intends to seek a stay on the decision and is exploring options which include appealing the decision or engaging with the FDA. The ban's part of the FDA's broader view of the vaping industry following years of pressure from politicians and public health groups to regulate the segment as strictly as other tobacco products after vaping became more common among high schoolers. Juul had sought approval from the agency for its vaping device and tobacco and menthol flavored pods, which are available at 5% and 3% nicotine strengths. The flavors were not subject to a 2020 agency ban on mint and fruit. A ban on those remaining products would deal a hefty blow to the company. The U.S. remains its largest market. Wow, so they're basically going to go out of business. The FDA said their applications gave insufficient or conflicting data about the potential risks of using the company's products, including whether potentially harmful chemicals could leak out of the Juul pods. Well, you're electrifying and vaporizing harmful chemicals and giving yourself popcorn lung. So good riddance. Artistic swimmer something.
Frightening moments for an American swimmer who fainted while competing at the 2022 FINA World Aquatic Championships last night in Budapest, Hungary. Team USA artistic swimmer Anita Alvarez was performing her routine in the finals when she began sinking to the bottom of the pool.
It looks like she's having problems.
Her coach, Andrea Fuentes, watching the routine unfold, can be seen initially smiling from the sidelines before she realized something had gone terribly wrong.
The coach is actually diving into the pool to get her out.
Quickly jumping in the pool to save the 25-year-old.
Two people are in the pool. I mean, we obviously can't see the pictures at the moment, but they are getting her out.
The dramatic rescue photographed underwater.
The coach, she reacted very, very quickly indeed. She's an Olympic swimmer herself.
Fuentes later releasing a statement on the USA Artistic Swimming Instagram page, saying Alvarez was seen by doctors. Anita is okay, she writes. All vitals and everything is normal. This is not the first time Alvarez fainted during competition. Last year, she briefly lost consciousness at the Olympic qualifying event in Barcelona, where she was also rescued by Fuentes. Alvarez's father spoke to Craig about the incident last year.
You could see the face on her, and the face just wasn't something you want to see on your child's face, and that was hard.
The head coach writing incidents like these happen in other high-endurance sports. Marathon, cycling, cross-country. We have all seen images where some athletes don't make it to the finish line and others help them to get there. Our sport is no different than others, just in a pool. We push through limits, and sometimes we find them.
Miguel, we heard the coach saying she didn't think the lifeguards were doing anything. Were there lifeguards on duty? Why didn't they respond more quickly?
Well, Savannah, that's a big question people are asking right now. Alvarez's coach told a Spanish radio program she decided to dive in because she saw the lifeguards were not jumping in and actually seemed paralyzed and dumbfounded. She even shouted at them at one point, she says, but they were not responsive. Luckily, Fuentes got in time just to bring her back to safety. Savannah.
Incredible. All right, Miguel, thank you so much. And the fact that she had done it before. I mean, it's a high endurance sport. They hold their breaths while exerting themselves.
Right, and it's happened once before, but wow. When I got to that coach, I'm sure she knew right away there was something that wasn't
wrong.
right.
Yes. All right.
High endurance sport. Artistic swimming is a high endurance sport. Wow. I wonder if that girl got the you-know-what in her arm last year. It's a quick one tonight. She took in water? Oh yeah, in her lungs, right? I'm sorry guys, I just don't got it in me tonight. I had a shit ton of mulberries. I felt like this was my last chance of the year before they're all gone. And I wanted to fast and work out, and I just ate so many mulberries, and then I ate a mango and 3 apples, and I just don't have it in me to continue reading and talking. I'm gonna make a salad. I'm gonna veg out. I'm going to work on my business plan tomorrow. I gotta get that done. It's high time. But yeah, I'm sorry I can't stay on. I'm gonna call it early.